Have you ever heard the saying, read the room, as advice for a public speaker or someone who's trying to make a decision? Well, it seems to me that 7th Circuit Court of Appeals Judge Frank Easterbrook has failed to read the room when it comes to where the Second Amendment stands in American life and with respect to this Supreme Court. Stay tuned. Let's talk about why I say this. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and proud author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Amazon. Okay, folks, we've done a lot of talking recently about these very important quote-unquote assault weapon bans and magazine ban cases out of the state of Illinois, the various federal cases, the ones in the Northern District of Illinois, which is out of Chicago, the ones in the Southern District of Illinois, which is an order or series of orders issued by Judge Stephen McGlynn, and the fact that they're both up on appeal, one to the United States Supreme Court, that's the Bevis versus Naperville case dealing with the National Association for Gun Rights, and then there's a series of other cases, including Barnett versus Rowell, that are now before the 7th Circuit Court of Appeals. We all know that just a day ago or so that 7th Circuit Court of Appeals Judge Frank Easterbrook, who was the author of the McDonald versus Chicago case that ultimately got reversed by the United States Supreme Court when Frank Easterbrook, Judge Easterbrook, wrote that decision in the 7th Circuit Court of Appeals. It then went to the Supreme Court for McDonald versus Chicago in 2010 and got reversed. Judge Easterbrook is the one that entered in a stay that prevented or stopped, if you will, the injunction against the Illinois state assault weapon ban and the magazine ban from going into effect. Again, as a reminder, Southern District of Illinois District Court Judge Stephen McGlynn entered an order that enjoined the Illinois state ban on assault weapons and large capacity magazines, all propaganda terms, of course. The state of Illinois took an emergency appeal to the 7th Circuit Court of Appeal, which is the Court of Appeals that oversees all of the district courts in Illinois. And they specifically asked for an emergency stay, which means a pause, a stop, a pause, of Judge McGlynn's order that enjoined the law from going into effect. And a single judge, Judge Frank Easterbrook, entered a stay order that says that he is staying the effect of Judge McGlynn's preliminary injunction, which means effectively that the order banning or preventing the gun ban from going into effect is no more. So now the gun ban goes into effect because of the stay of the preliminary injunction entered by Judge Easterbrook. Now, I want to talk about Judge Easterbrook here because he has a long history of doing bad things to the Second Amendment, and everyone in the Second Amendment community knows this. In addition to getting reversed on the McDonald case, as you recall, the McDonald case says that Americans have an individual right to keep and bear arms, and the states and localities cannot prevent them from doing so. In other words, the Second Amendment applies not just to the federal government, but also against the state and local governments. Judge Easterbrook has more bad history when it comes to the Second Amendment. He is also the author of a case called Freedman versus Highland Park. Now, this was a decision that upheld the quote-unquote assault weapon ban and large capacity magazine by Highland Park, Illinois. After he upheld it, there was a cert petition filed. The Supreme Court rejected the case and did not take it, but there was a robust dissent against the decision not to take the case by Clarence Thomas and Justice Scalia, laying out in great detail that Judge Easterbrook's decision at Freedman was terribly flawed and completely inconsistent with the Heller decision in all respects. As you know, Heller said that if a firearm or if a type of arm is in common use for lawful purposes by Americans, it cannot be banned. Period, full stop. Heller dealt with handguns. The Highland Park or the Freedman versus Highland Park case dealt with long guns, semi-automatic long guns. Now, Judge Easterbrook entered an order or wrote an opinion in the Freedman versus Highland Park case that upheld the ban on semi-automatic weapons, long guns, and also on these so-called large capacity magazines holding more than 10 rounds. Now, let's be clear here. This is what Judge Easterbrook wrote, which is entirely inconsistent, as you know from watching this channel, with the standards set forth by Heller. This is what Judge Easterbrook wrote in Freedman, and you're going to see why this is important today. Today, you'll see. Judge Easterbrook wrote, quote, "We think," that's we, the 7th Circuit Court of Appeals, back in the Freedman case from 2000, 2015. Quote, "We think it better to ask whether a regulation bans weapons that were common at the time of ratification or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia, and whether law-abiding citizens retain adequate means of self-defense." That is total, I don't want to use the word here because I'm going to be polite, but this is just utterly silly in light of the clear holding of Heller. This is made-up stuff by Judge Easterbrook. Literally, you can explain something to Judge Easterbrook. That doesn't mean he's going to understand it or follow it. I suspect, here's my speculation, I think it's because Frank Easterbrook believes he should have been on the Supreme Court and is probably, this is my best speculation, my best guess, is Judge Easterbrook is probably upset that he never made it to the Supreme Court. So, therefore, he thinks he doesn't need to follow the Supreme Court because he views himself as on par. That's just my guess about the views. That's just my guess. Take it for what it is. Nevertheless, that was his interpretation of Heller, which is just silly. Total silliness. The good news is you don't have to trust Mark Smith in the Four Boxes Diner. You see, Justice Thomas, who, by the way, is the author of Nysurpa versus Bruin, and Justice Scalia, who is also the actual author of Heller, rebuffed clearly and scolded Judge Easterbrook when they dissented from the denial of cert. This is what Justice Thomas, joined by Justice Scalia, said about the views of Judge Easterbrook when it comes to his interpretation of Heller and the Second Amendment. Quote, this is not me, this is Scalia and Thomas. Thomas authored Bruin, okay? Quote, instead of adhering to our reasoning in Heller, the Seventh Circuit, Judge Easterbrook's opinion, the Seventh Circuit limited Heller to its facts and read Heller to forbid only total bans on handguns used for self-defense in the home. All other questions about the Second Amendment, the Seventh Circuit concluded, should be defined by the political process and scholarly debate. But Heller repudiates this approach. We explained in Heller that since the case represented this court's first in-depth examination of the Second Amendment, one should not expect it to clarify the entire field. We, the Supreme Court, caution courts against leaving the rest of the field to the legislative process. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges, think Frank Easterbrook, think that scope is too broad. Now, based on this is again, the Supreme Court continues. I should say, Justice Thomas, Justice Scalia continue attacking the views of Frank Easterbrook. Remember, it is Judge Easterbrook who entered the order that enjoined, or I should say stayed, the injunction by Stephen McGlynn, allowing the Illinois assault weapon ban to go into effect. Frank Easterbrook, Judge Easterbrook is the one that did that. Justice Thomas, with Scalia joining, continued on with their criticism of Judge Easterbrook in the Friedman case. Based on its crabbed reading of Heller, the Seventh Circuit felt free to adopt a test for reassessing firearm bans that eviscerates many of the protections recognized in Heller and McDonald. The court asked in the first instance whether the banned firearms were common at the time of ratification, but we said in Heller that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Then Clarence Thomas, with Justice Scalia, goes on to say, the Seventh Circuit, which is, again, Frank Easterbrook's opinion, the Seventh Circuit alternatively asked whether the banned firearms relate to the preservation or efficiency of a well-regulated militia. But the court concluded that the state and local ordinances never run afoul of that objective, since states which are in charge of militias should be allowed to decide when civilians can possess military-grade firearms. But that ignores Heller's fundamental premise. The fundamental right, the right to keep and bear arms, is an independent, individual right. Its scope is defined not by what the militia needs, but by what private citizens commonly possess. Moreover, the Seventh Circuit, Judge Easterbrook's opinion, the Seventh Circuit endorsed the view of the militia that Heller rejected. We explained that Congress retains plenary authority to organize militia, not the states, because the Second Amendment confers rights upon individual citizens, not state governments. It is doubly wrong for the Seventh Circuit, that's Judge Easterbrook's opinion again, to delegate to states and localities the power to decide which firearms people may possess. Lastly, the Seventh Circuit, Judge Easterbrook's opinion, the Seventh Circuit considered whether law-abiding citizens retain adequate means of self-defense and reasoned that the city's ban was permissible because if criminals can find substitutes for banned assault weapons, then so can law-abiding homeowners. They go on to say that Frank Easterbrook's view, Judge Easterbrook's view, misreads Heller. You see, the question under Heller, according to Clarence Thomas and Justice Scalia, the question under Heller is not whether citizens have adequate alternatives available for self-defense. Rather, Heller asked whether the law bans types of firearms commonly used for a lawful purpose, regardless of whether alternatives exist. And Heller draws a distinction between such firearms and weapons specifically adapted to unlawful uses and not in common uses, such as sawed-off shotguns. The city's ban is thus highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. Roughly 5 million Americans own AR-style semi-automatic rifles. Remember, this is 2015. The numbers are much higher now. The overwhelming majority of these citizens who own and use such rifles do so for lawful purposes, including self-defense and target shooting. Under our precedents, that's the Supreme Court precedents, under the Supreme Court's precedents, that is all that is needed for citizens to have the right under the Second Amendment to keep such weapons. Bottom line is this. Why am I telling you all this, and why does it relate to the Seventh Circuit Court of Appeal decision involving Stephen McGlynn? What does Judge Easterbrook write in his decision that stays the order of Stephen McGlynn, Judge McGlynn? Let me read it to you. Judge Easterbrook, 2 days ago, said, the motion for a stay of the district court's preliminary injunction is granted, which is bad for us, pending further order of the court. But here's the key. Ready? You're not going to believe this, folks. You're not going to believe this. Judge Easterbrook wrote, any response by the Second Amendment plaintiffs, any response should discuss the bearing of Freedman versus Highland Park. You hear what I just said? Judge Easterbrook is specifically asking the parties to brief whether or not Freedman versus Highland Park, which has been completely eviscerated, not just by Heller, but also by Bruin, is still relevant. So it seems to me, if you read between the lines, that for some reason, Judge Easterbrook still thinks that Freedman versus Highland Park is somehow relevant. Now, I will tell you that even the lower courts, including Judge Kendall that ultimately ruled against the Second Amendment out of Chicago, even Judge Kendall concluded that Freedman versus Highland Park has no bearing anymore because it's been eviscerated by the Supreme Court in Heller and in Bruin. Nevertheless, Judge Easterbrook continues to apparently hold on to thoughts that his opinion in Freedman versus Highland Park is somehow relevant to anybody except the history books. If you're sitting on the Seventh Circuit Court of Appeals, as Judge Easterbrook currently is, you ought to know, in my view, that you have Justice Thomas, who just wrote the Bruin opinion, has already said to you in the Freedman versus Highland Park case, where he dissented from the Supreme Court's refusal to take the case, that your decision in Freedman versus Highland Park was completely, entirely wrong. My guess is that Judge Easterbrook probably knows in his own mind that what he wrote in Freedman was inconsistent with Heller and didn't care. Again, speculation on my part, I'm guessing, but I feel kind of like I'm right on this. We'll see. And last but not least, Judge Easterbrook should also know that Judge Kavanaugh, who's now Justice Kavanaugh, unlike Judge Easterbrook, he's now Justice Kavanaugh. Justice Kavanaugh, when he was a judge on the D.C. Court of Appeals, issued the decision in Heller 2. Specifically, he wrote a dissent in Heller 2, and in his dissent, he specifically said that semi-automatic rifles are protected arms no different than handguns. So if you read the room, and you read the Bruin decision clearly, you read the criticism of you in the dissent in Freedman versus Highland Park, you read the opinion of Judge McGlynn, it seems to me that if I were sitting on the bench as Judge Easterbrook, it's a pretty straightforward case to let the injunction entered by Judge McGlynn continue on and not be stayed. Because it's pretty clear to me that the Heller test in common use is the law of the land. Bruin reaffirmed that test repeatedly. The Catano case reaffirmed that test. Judge Stephen McGlynn in the Southern District of Illinois wrote a very thoughtful opinion that lays this all out beautifully, as I see it. Someone that actually understands firearms and firearms technology. And yet here you have Judge Easterbrook entering a stay, preventing that injunction from continuing. Now, I hope that Judge Easterbrook is going to get this right. But I suspect that if he doesn't get this right, it's going to be very interesting to see what the U.S. Supreme Court does, given the fact that it seems to me, looking at the record, that Judge Easterbrook has a history of getting Second Amendment things wrong, especially from the perspective of the current composition of the Supreme Court. Because again, Judge Easterbrook is the one that wrote the Seventh Circuit Court of Appeal in McDonald. They got overturned by the U.S. Supreme Court. He then wrote the Freeman decision, which Scalia and Thomas would have definitely tossed out if the Supreme Court had taken the case. And of course, he simply has ignored the fact that Judge Kavanaugh has the same exact view as Thomas and Scalia did on this question, and Judge Kavanaugh is no longer Judge Kavanaugh. He's now Justice Kavanaugh and no longer sits on an inferior court as defined, of course, by Article 3 of the U.S. Constitution. So let us see what happens here going forward, but hopefully good news for the Second Amendment will come out of the Seventh Circuit Court of Appeals. We all got our fingers crossed. Okay, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.